Ms. James, could you unmute yourself? I just want to make sure I can hear you.
Can everyone hear me?
Attorney Burrell? Yes, I can hear you.
You can. Okay, very good.
There's a delay
Okay.
between my speech and my audio and video, but Ms. Burrell,
Yes.
can you unmute yourself so we can hear you?
I am unmuted. I don't know if Miss James is. Can everyone hear me?
Okay, Ms. James. Yes, Ms. James, can you introduce yourself? Ms. James?
Yes.
Okay, good. This is a single justice matter 22J37, a summary process bond appeal. I'm Justice Sabita Singh. I'll be presiding for this hearing. Ms. James, can I hear your position? I understand that generally you're seeking to reduce the use and occupancy payments.
Correct. So I was going in front of the judge to reduce use and occupancy because I filed raft and I needed the monies to be able to move. But since I filed the motion, the landlord has worked with raft and they process payment and he's getting paid through them.
I'm sorry, I lost some of your audio. You're saying the landlord is working with you.
He's now working with me.
So what does that mean for the use and occupancy payments right now?
So the use and occupancy has been paid through raft. Can you hear me? Did you hear me?
Go ahead.
So the use and occupancy has been paid through raft.
Okay, so are you saying you don't need a ruling from this court anymore?
At this time, no, I do not. I think it's all set. He's worked with me. He's worked with raft, and I think everything's squared away. All the past due has been paid, and they even paid forward a few months.
Okay, let me hear from Attorney Burrell.
Your Honor, I contacted my client this morning. My client submitted everything to raft on December 23. Ms. James has not completed her portion of the raft application. So the application is not complete. No payments have been received for use and occupancy, that is, for January or February of this year in the amount of $1,850 for each month. So no payments have been made. There is nothing forthcoming from raft because the application is not complete because Ms. James has not completed her part of it. And so my client obviously feels that the original order should stay in that she needs to make use and occupancy payments for both January and February in accordance with the order to keep this appeal alive.
I actually got the email from raft and have the proof that they submitted payment, that the application has been processed. It's paid in full. The application is actually closed out because they paid in full. And I talked to them yesterday as well. There was nothing on my end waiting, that the landlord had to fill out all the documents. I could not fill them out or sign them. So it had nothing to do with me. My application was finished out in September, and I asked repeatedly for the landlord and you to work with me over and over again. And nobody would work out with me until December 23rd. That's 3-4 months after I completed my application. If you want, I can forward the email to you showing all the payments that they have processed that they sent me.
Well, actually, I think that the position that the court is in right now is that if you are not seeking to have the use and occupancy reduced at this point because you think that the matter is settled, then I don't think that there is anything that I need to do, that the use and occupancy order of the trial judge stands.
Yes.
Attorney Burrell?
I agree with the court. If
Is it-
whether or not, now obviously it's my client's contention that those use and occupancy payments have not been paid. And there is no argument being made by Ms. James that for a reduction in those payments. So they need to be paid.
Well,
That order
this is the
needs to.
thing. I can argue a reduction.
Okay, so I think there's no
in
issue before me. If there's an issue, maybe for the, sorry?
So I can argue
Ms.
use and
Day?
occupancy to be reduced, but if I argue the reduction, then when Mr. O'Brien gets the payment from Raft, he's gonna have to pay them back. So if I don't argue the reduction, then he's gonna be
Sure,
able to
so why don't
complete the funds.
Okay, but this is your opportunity. Do you want to, what's your basis for arguing for a reduction in use and occupancy?
The argument for use and occupancy is because the landlord wants his property back as soon as possible. If I continue to pay use and occupancy, I will not be able to put the down payment on an apartment that I found because they are refusing to work with Raft. So in order for me to give him his property back as soon as possible, then I would not be able to pay use and occupancy out of my pocket so I can put in for a deposit on a new place so that I can move out hopefully by March 1st, April 1st in that time frame. Otherwise, I will have to either look for another place, which it's already taken me a very long time just to find a place, or I'll have to wait to find somebody that will work with Raft, which has been very expensive anyways. And then we could end up being there way longer. And I'm just trying to resolve the matter as soon as possible.
Okay, so you're making an argument of sort of practicality. You're trying to have a you're trying to place the situation in front of the landlord as to why this would be in his best interest. But you're not making any argument to me as to the fairness of the use and occupancy amount. Is there anything wrong about the amount that's been set?
So the amount that's been said, it's not wrong at this moment. I'm going to be completely honest. No, prior to, yes, because we couldn't use the full land that was available on the house. Now it's situated and
Okay.
it's fixed, but before it wasn't.
Okay. Very good. I appreciate that. Attorney Burrell, anything else before I conclude the hearing?
Just this, Your Honor, I agree with the court that the current amount should be kept where it is, $1,850 a month, and also that the order that payments need to be made for January and February needs to remain. Now, I'm hearing for the first time that Ms. James might have another place to move to, and obviously I'm going to relay that information to my client, who's going to be very interested in that. If we can work out something where we get paid for January and February, and if she can show us a lease or something where she's guaranteed another place to move to, I think we can resolve this without even carrying the appeal any further. Because my client's interested in having her move, and she's sounds like she has a place to go. So I think we could work this out. But we do need the order to remain that she is responsible for January and February, because even if Raft were to pay, we don't want an order saying that Raft doesn't have to pay it, because it does need to be paid, either by Ms. James or by Raft. But it sounds like we can work this out outside the court at this point, because I was unaware that she had a place to move to until now.
Well, I did notify you in the email that I had a place to go, that I just needed the rent to be paid by Raft and the information filled out by the landlord in order for me to get the place. So the emails and the phone calls and everything were there. It was all in there.
Thank you, Ms. James. Thank you to both parties. I think I have what I need to conclude the matter, and the parties will be notified.
All right,
Thank
thank you very much, Your Honor.